Well, thank you, Karen. And thank you so much to SSAT for having me back again. Many of you may have attended the webinar that we offered in May, and as a result of the attendance and the interest at that time, I proposed that we have just an open F1 SEVIS Q&A, a question and answer period, because you had so many questions last time that it was very, very difficult for us to be able to even get to them all. So this is really just an opportunity for you to ask your F1 SEVIS questions, and I will do the best I can to respond to them. I know that we got some advanced questions submitted, and we will start with those at the end. I came up with a very brief presentation to maybe get your juices flowing, so to speak, to think about what your questions may be if you don't think that you really have any on the tip of your tongue. And so many of you know that I do, part of the work that I do at IETS is that schools ask me to come and do compliance reviews to determine whether or not they are in compliance with F1 SEVIS requirements at their school. And after, some 25 years of doing this kind of thing, I've come up with a few things that will just tell you what are the major pitfalls or issues that I encounter where schools are perhaps running into difficulty in being compliant with federal requirements. So I'm going to go into those just briefly, and this is really not meant to be training, but to just kind of, inspire you to think about what is going on at your school. So the first compliance pitfall that I run into at many schools surrounds the role of the principal designated school official, the PDSO. The PDSO may often not meet the federal requirements for the job. And when I say the federal requirements, what are those federal requirements? Generally, SEVP requires that the principal designated school official be what I call the best and the brightest in the F1 SEVIS world at the institution, meaning the person who is absolutely the most knowledgeable about F1 SEVIS matters, and that person is supposed to oversee and supervise other designated school officials at the institution so that the school is on one federal compliance page and everyone knows what each other is doing. And so oftentimes I find that the PDSO is not the person who is the most knowledgeable, and that can pose a very difficult situation for compliance. Because if an SEVP field representative or any other Homeland Security officer comes to visit, they're making a beeline right for the PDSO, and they expect that person to be able to sit and have a very intelligent conversation with them about all things F1 SEVIS. The other thing I find is that even if the PDSO does meet the federal requirements for the position, often that person does not have the appropriate support or clout to get the federal compliance job done. And so I'm always in my training talking about how PDSOs need to communicate and to educate the institution about all of the F1 SEVIS compliance duties, and to make sure that no is never an appropriate response when it comes to compliance duties. The school needs to find a way to fulfill its job for the government, which is compliance. So that is where everything starts, is with the PDSO and making sure that person is properly resourced and is able to lead the school into compliance. The next thing that I find is that designated school officials, whether PDSOs or DSOs, have not been properly trained. And you may recall, I think we talked about this briefly in our last session, that when your head of school appointed a DSO to do this job for the school, the head of school promised the DSO adequate resources and training to do the job. And the school is held completely accountable for the training of DSOs to make sure that they are doing the right thing. So all DSOs need to be properly trained. If you have anyone on staff who is a DSO who has access to SEVIS who is not properly trained, that is an area of great risk for the institution if that person were to do something that was not in compliance with federal requirements. So that's another area that I run into. The third one is about the institution's compliance with the school reporting requirements. So as a SEVP approved school, you're only supposed to operate as you have been approved to operate, and you can't step outside of that operation. So it requires you as a DSO to make sure you know what your I-17 says that you have been approved for, and exactly what you are able to do at your institution. And sometimes your school may have plans to make changes in the way it operates. It may be deciding that it's going to have a summer camp, it's going to have a special kind of summer program, whatever the case may be. And this poses a problem because when your operations change, your I-17 must be updated, and it must be updated within 21 days of the change being made. And sometimes the change may require government approval, just like adding any new program may require government approval. So oftentimes I find that the PDSO, who I really believe is the appropriate person for updating the Form I-17 and communicating with SEVP of such changes, that person often may not be the person who knows what is coming down the pike at the school. So again, it's a matter of educating the institution that whenever anything is planned as far as an academic change or a change to our I-17, then the government must be informed. I say that SEVIS is the last stop on the train. You know, once licensing and accreditation issues have been dealt with, before F1 students may be involved in a new program of study, the Form I-17 will have to be updated. And oftentimes they don't know. Suddenly someone says to them, well, we want to add this new thing, and they kind of go, no, we can't, because it could take upwards of 5 months for this to be approved by the government, and we cannot issue I-20s for it until such time as it is approved. So that is often a difficult thing. So make sure that you lay your pipeline of data management with your seniors, supervisors at your school, your chief academic officers, that you have to be brought into the loop whenever there is any change that's going to require federal updates to your Form I-17. The next thing that I find is often a problem is that the I-20 issuance requirements are not being met. When you issue a Form I-20, you are legally certifying two things to the government. You are certifying that the student to whom it has been issued has been fully admitted to pursue a full-time program of study at your institution, has met all of the requirements for admission to your institution, and secondly, has proven to the school that she is capable of affording the costs that come with pursuing that program of study at your institution. So that is what it means when you sign off on an I-20. The student's been fully admitted and has the funding for the program of study, the ability to afford the program. Many schools only are asking to see that there has been sufficient funding presented for the first year of study, or even less than that in some cases, I find. But most commonly that the first year of study is covered, or the student is able to pay. If that is the case, then your school is not in compliance with federal requirements, because the government's requirements is that the student be able to show that they can afford the costs for the full length of the program of study. Now this, as far as what constitutes appropriate proof in accordance with federal standards, this I teach a whole workshop on in and of itself, and I also do have a webinar on it, which is available on our website for you to purchase and download if you would like. But this does require appropriate training for you, but actually you just have to be able to do your due diligence and see that you believe that there are appropriate funds that will be provided the student for the full length of the program of study. The next area relates to student data not being properly reported to the government. And this is just a list of all the student data that must be reported in a timely fashion to the government. And again, this is a very, very detailed area that requires appropriate training. But I'm often finding that student data is not properly or timely reported. And mainly the reason is because the DSO has a hard time getting the data from the appropriate sources to report it timely. Perhaps the DSO does not know if a student has enrolled or has been granted a medical leave from the institution and is dropping out. This is all data that is reportable. And again, I see this as a major PDSO function to sit down with the appropriate folks at the institution and say, how are we going to know? Because we must know this information in order to be able to report it timely. At the start of the term, you only have 30 days to report it. And once school has begun, you have to know if something happens along the way where a student is no longer going to be enrolled, and you must be able to report it timely in 21 days. And I often find that schools are just not able to get that data in time. And the last issue I see is that schools are not keeping appropriate records. And I always say that every time you do anything in SEVIS, there is a record that must be maintained and with appropriate evidence and backup that the student qualified for the action. And there is a great deal of information that goes into this to make sure that you are in compliance with record keeping. But every SEVIS action has a regulatory foundation, and were SEVP to come, or any Homeland Security officer to come, they could easily ask you, why did you give this student a program extension? Did this student qualify for it? And you have to know what the legal requirements are for qualifying for a program extension, and have evidence that that student qualified. So all of these things are the major points I find as difficulty for institutions in being in compliance with federal requirements. And I hope that's gotten your questions, flowing. And so now I'm ready to, I took even more time than I thought I would on this, but I'm ready to take your questions.
Okay, thank you so much, June. I think first we're going to, would you like to launch the survey at this point?
Oh, thank you, Karen. Yes, I did want to ask you folks, and Karen and I were discussing this earlier, how many of you have been contacted by your SEVP field reps? And I thought it would be nifty to get an idea whether any of you have received an email or a phone call from that person, or even more, have already had a visit. How many of you?
Okay, the poll has been launched, June, and we're looking at about 60% voting at this point, so we'll keep it open for just a little bit longer.
Wonderful. And in the meantime, should we start taking any other questions?
Absolutely. I can do the first one right now, actually. The first question is, for the SEVIS accreditation conversion, what should we do if we cannot get the date of state recognition, not accreditation?
Well, actually, I don't know the answer to that question. That would be something that would have to be researched. The school is supposed to have it, of course, and be able to provide it to the government. I would say that if you have looked at the frequently asked questions on the study on the state's website about this conversion, I don't know if they answer that question for you or not in there. I would start with looking at the FAQ and see if that is one of the questions that they have answered. If they have not answered that question for you then you're going to have to send an email directly to SEVP and ask them that question because I really don't know how they would address it. They may just say you have to get it, or they may say do without it. I can't say.
Okay, thank you. We've had the poll open for a little over 2 minutes at this point, so I'll give everybody a couple more seconds in order to vote if you haven't voted yet. And we'll go ahead and move on to the next question before I close the poll. June, the next question is, what documents do we need from new students in order to create an I-20?
Okay. As I said in even this presentation, you have to be able to see that the student has been fully admitted. All requirements for admission have been met. That's the academic side. The second side is you must see that there is evidence that has been presented that convinces you that the student does have sufficient funding for the educational objective. So if the student is coming for a 4-year high school program, you have to see that there is someone who is promised to sponsor her. So that would be that there would be an affidavit of support. And that person, whoever is, or persons, because it could be multiple persons that are saying I'm going to contribute to this child's support, that person or persons is actually capable of meeting the obligation. And so really, without going into detailed training at this time, It's pretty much like if you and I were going to go and get a loan to purchase a new car. Think about what evidence a bank loan officer would be asking you for if you were going to qualify for a loan. They're going to want to see that you have substantial resources and income that would enable you to pay your monthly loan on your car. Well, that's really the same in terms of government standards. They want to see that the student does, their sponsors do have adequate financial resources and income to support the student. Any more than that would require us to go into the detailed training as to the very specifics of what constitutes adequate resources and income, and we just don't have the time to do that here, but there is training available on that.
Great, thank you, June.
How'd we do, Karen, on our poll?
I'm going to go ahead and share that right now. We had a whopping 81% said no, they have not been contacted, and 19%
Okay.
have.
And so almost 20% has been contacted.
Correct.
Yes?
Yep, we're almost exactly at 80-20. No to yes.
Very interesting. Very interesting. And I have not heard anything that indicates why or how or who is making these plans as to who gets contacted and who doesn't. There is no information sharing on that I have seen thus far. So that means that those of you who have not yet been contacted have time to make sure that you're in really good shape. So we think we've got another question.
Okay, the next question is, can a PDSO pull the I-94s from the website, or does the student need to provide the I-94 to them?
The student does not have to. I think it's a good idea for the student to get used to the CBP portal through which they may get it. So how you do this is really up to you. I know that many schools are working with students once they arrive to at least the first go-round. Some schools are doing it together with the student, having the DSO sit down at the computer and go into the portal with the student and bring up the information. It is available for anyone to be able to pull. If there is no security feature on this, you simply need the name of the student to be able to access it. And of course you need the name as the student entered it when they came into the United States. So you can do it either way as you would like. Either you go in with the student so you can get it, or have the student bring it in. It's a matter of choice for you. We got any more?
Oh, absolutely. The next question is, what is the actual signing requirement on I-20? The form says each year, but in practice it is every 6 months.
Well, a word has to be said about the Form I-20. The Form I-20 is a document that hasn't been updated in many, many years. So a lot of the information and instructions on the Form I-20 is really outdated. So you really can't go by that statement on the back anymore that says that the DSO's signature is valid for 1 year. I believe that no longer really fits the SEVIS environment. My recommendation is that you sign this every academic session at your institution, once a term essentially. So once for the fall and once for the spring would be a really good practice. What you are certifying when you sign for a student to re-enter the United States is that this still is a bona fide student at your school, still intending to pursue a full course of study at your institution. If you believe that you can certify that simply once a year, then that's fine. Many schools feel more comfortable certifying that each term in the event the student were to stop attending and the record to be terminated. They do not want to have their signature on an I-20 that might allow the student to use it after that. So that's usually the issue that comes up with the endorsement. So once you understand what you are certifying, then you can come up with the best practice for your school. Next, Karen.
The next question is, will every school be visited by ICE?
That's what they say. I think it can take a while. If we see right now that only 80% have not been contacted at all, clearly this is going to be taking some time to roll out. And they are just going into their second round of hiring of the next SEVP field reps. So don't forget that right now they only have, I believe, 15 nationally out of the planned 60. So there aren't that many to go around right now. So obviously they have set their priorities that are not being communicated, you know, you're just not all in line right now. But eventually, once they get up to the full 60 complement, I'm sure everyone will be contacted, yes.
Okay, thank you. The next question is, will SEVIS approve of a new school working toward its first accreditation?
The question is how new. The government generally requires a school to be, quote, established before they can qualify for SEVP approval. Normally, their standard for established is that the school must have been in operation for a 2-year period and be able to show those operations for 2 years. So a brand new school does not get SEVP approval right away.
Okay, thank you. Now you did touch on this a little bit earlier in your presentation, but the next question is, who should be appointed the DSO title?
As I said earlier, the most knowledgeable person in this field. And if you're all equally knowledgeable, I would say that someone who is going to be able to get their hands on the data the most easily. So it usually is someone who is going to be able to blaze the trail through the data and get her hands or his hands on the pipeline of communications and likely have the clout to get this job done. So there's no one size fits all here. It really depends on how your school operates. I particularly am not a fan of it being in admissions, although it's very common. It is in admissions. Oftentimes, if I-20 issuance is in admissions, there is the notion that this is potentially a conflict of interest in admissions. And the reason I think you can probably figure out quite easily is that admissions is very concerned with getting the enrollment at the institution. And so there is concern that the institution may not be doing its due diligence on proving student funding and therefore may be soft on the financial evidence that is required for the I-20, because potentially the person issuing the I-20 could easily be saying, no, I'm not issuing an I-20 to this student because we haven't gotten evidence, and there could be pressure brought to bear that we have to get that person in. So there are those issues that need to be considered about where is this appropriately housed, and that the designated school official or the person, PDSO, if it is a PDSO, may often be saying, no, we can't do certain things, and that person has to be able to be assertive enough and strong enough to say no to people that might be not concerned about compliance, because as a compliance officer, which is what you are when you're a DSO, you're an unpaid employee of the federal government. When you're a compliance officer, you have signed that you are sworn to uphold the federal regulations. And so sometimes that will mean saying no to your institution. So there's got to be a lot of thought given to where this belongs at the school, at your school.
Okay, thank you. Joe is asking, we have a new headmaster arriving July 1st. Is there any documentation that needs to be completed to note this transition?
No, the I-17 does not ask for the name of the headmaster. So, however, I would make sure that the new headmaster was aware of this function, so there may be some education going on in this area and meeting that person about what we do and all of that kind of thing, but no updates to the I-17.
Okay, thank you. John is asking, when is SEVIS 2 rolling out? What is the most recent update?
It's not coming. There is no SEVIS 2 coming. The government has totally scrapped its plans for SEVIS 2. As to why, I'm really not sure. There's a lot of different reasons for this. What they have decided to do is to put its current efforts into making the current SEVIS work better. So we are going to expect to see quite a number of changes in the current system, and those are going to be rolled out gradually over time. So they're probably going to be incorporating some of the elements that they were planning to put into SEVIS 2 right into the current SEVIS system. So they've abandoned any plans for that, at least for now.
Okay, thank you. Kathleen is asking, does the PDSO need to keep hard copies of anything changed in SEVIS for each student?
I didn't catch that, Karen. Say that again.
Okay, sure. You're cutting out a little bit audio-wise.
I am?
Just a bit. Kathleen is asking, does the PDSO need to keep hard copies of anything changed in SEVIS for each student?
If hard copies of anything changed,
correct.
Changed
Yeah.
in SEVIS, you need to keep records of every action you perform in SEVIS. It doesn't have to be hard copies. It can be things that you scan and keep in any acceptable format at your institution. So you can go fully electronic. You don't have to keep hard copies. It just has to simply be available, and you have to keep it for a 3-year period once the student is no longer enrolled. But hard copies are not a requirement, no.
Okay, thank you.
Can you hear me okay now?
Yes, you're coming through a little bit clearer, June.
I'm not hearing you well, though.
Oh, I'm sorry. Okay. If anybody's not able to hear me, please let me know in the
Your
chat box.
the volume went way down.
Okay. Let me see if I can fix that. Okay. Mary Lou is asking, would you recommend issuing an I-20 for a student who wants to study for one semester, or would that not be considered by SEVIS to be full-time?
I can't hear you.
Oh.
You're very faint.
Okay. Is this a little better?
No.
Okay. June,
You're like totally going
I'm going
on
to
me.
send these questions to you, and you will see them in your question box.
Gone. Now I can't hear you at all.
June, if you could look in your question box, I'm gonna send these questions directly to you since you
I
can't hear
can
them.
see your audio moving, but I can't hear you.
Okay, you still can't hear me at all, June?
I don't know what's happened. It's like it's totally gone.
Okay, June, can you hear me now? June?
Yeah, I know you're talking, but can you hear me, I guess? I don't.
Yes, I can.
I can't hear anything.
Okay. If you could check your chat box check your chat box, June.
Oh, I'm so sorry for everybody. I was having such a great time answering all of these questions. If there were any way I could see the message board and you folks can hear me, I would be able to respond to questions that come into the message board without Karen. Let me see. Oh, I see. Okay. Question box. Now, I can't see where that is, but I can see the questions up above. So let me answer those. Would you recommend issuing an I-20 for a student who wants to study for one semester, or would that not be considered by SEVIS to be full-time? Well, no, full-time is the number of hours the student is pursuing the study at the institution. So if that is a full course load, for the student, and in high school you always have to be full-time, so that would be full-time. The only reason that this would be a potential problem is what is the educational objective of the person coming for just one semester or 1 year. And yes, an I-20 can be issued for a student who's coming for one semester or 1 year. Sometimes they're coming for any number of reasons, and as long as they're fully admitted to your school and show that they have the funding, yes, they can be issued Forms I-20 for one semester or 1 year or 2 years, whatever the case may be. I saw the next one was a family's financing can change, and some families pay annually based on incoming income. What happens in this case? Let me see that. Well, when you are issuing the I-20, you are looking at the evidence based on is the family earning sufficient income at this time to be able to afford the student's costs on an annual basis. So it's based on what you know at the time the I-20 is being issued. So it's, yes, things can happen after a student is enrolled at your institution, but that's not an I-20 issuance question. So at the time, you have to be able to see that there is a family that is supporting the student or friends or whatever the case may be, and that those individuals, based on the evidence they have presented at the time, look like they can afford the costs. So I think that that answers that question. An F1 student has obtained resident alien status. So that's a green card. Now, do I need to keep him in active SEVIS status? The answer to that is no, that if the student has obtained the green card, then the government is actually supposed to remove that person when that has been approved. If they have not shut down the student's F1 record, you should contact the SEVIS help desk and tell them that the student is now a lawful permanent resident of the United States. And they will probably ask you to fax over evidence to that effect or scan it and send it, and they will change it for you. You should not be the one to do anything to the record. Let the government do it. If a student transfers to another non-U.S. or non-SEVIS school, how should they be listed, terminated? Well, it depends on what the student is. You know, if the student is stopping attending your school prior to completing high school, let's say, for example, then that student is held accountable for returning to your school in the next academic session. If the person leaves you without transferring properly, then yes, you would be terminating the record at the start of the next academic session when you're required to report the student. If the student graduated from your school and their record was completed by SEVIS, and you let the SEVIS system complete the student's record itself, you should never complete the student's record. The SEVIS system should do it themselves, itself. So then it will be simply that the student has gone, and the student is held accountable for doing everything properly. So if the student is transferring to a school in Canada, like this one indicates, then the student would have left the United States, hopefully in the 60-day grace period following completion of studies at your institution, and there would be no problem. So the student's held accountable for doing the right thing. So if they're staying in the United States and not going to a SEVIS-approved school, then it would be just as if they just have dropped out of your school altogether, and therefore you would have to be reporting that unless they have graduated. Is there a list of resources available to provide training, conferences, or webinars to attend for DSOs, especially with new compliance issues? Excuse me for a second. Would you recommend semi-annual conferences, I recommend getting as much training as you can. Which reminds me that I would like to show you the next screen, and I don't seem to be able to. It says it's showing my screen, but I can't change it. On the next slide, I have information about our upcoming training programs. We are doing a compliance workshop. All of our workshops are in New York City, unless you get a group of people together and ask us to go elsewhere in the United States, then we'll go. But in New York City, we have the F1 Basics program on July 23rd and 24th coming up, which is full DSO training. And on July 31st, we have the F1 SEVIS compliance workshop coming up. So that's from the IETS side, and we're considered to be one of the best trainers there is, according to all who've participated for the last 25 years in our training. There is a free online training program that SEVP runs, the DSO training module, that is quite good, that you could participate in and take as many times as you'd like. And it's online at ICE's website. And then there is NAFSA, the Professional Association for International Educators, and at their workshops they have F1 training as well. So that's pretty much the training resources that I am familiar with. But yes, training and keeping up to date in this field is a major factor. What needs to be on file for a visit from a SEVIS team? All of the records that I showed you on these slides, and as I said, you really need to get training to make sure that your records are in compliance. Let me see. What if we issue one or multiple I-20s and then need to cancel them because for some reason the students are unable to come to the school last minute? You can only cancel an I-20 if the student has not yet arrived in the United States and you have done your due diligence in verifying that. In other words, you should make sure there is no port of entry record in the SEVIS system for the student. We have had some students be very creative in fooling their schools that they could not get in and they're actually here in the United States and the schools did not know it. You should do that if you at all can get the information. But other than that, the government does not have a requirement for you to cancel a student's record, but they ask you a favor to cancel it if you have information that the student is not going to be coming. And so I recommend that you have a procedure in place for getting something in writing by email or however you would like to get it, that I am not in the United States and I am not going to be coming to your school, and so you have that information and you can therefore cancel the student's record in SEVIS. With regards to financial support, do we need to obtain a bank statement showing a balance that covers tuition, or is a bank letter stating that they have the funds necessary enough? Bank letters are not considered to be acceptable evidence from the federal standards that we have seen. So the government and the bank statement is not enough to prove future funding unless the person is very, very wealthy and has a whole lot of money in the bank, which is usually not the case. So a bank statement is normally to prove that the funding is available for the first year of study, and proof of income is usually what convinces the government that the student has the ability to pay for the future. But when you are looking for what type of evidence from the bank, the type of bank statement that is the most acceptable is the kind that you and I get from our banks every month that show the regular income and outgo of money, and not something that is written by a bank officer. If students are making multiple re-entries in an academic year, how often should we be pulling the I-94 record and keeping that current on file? That's a really good question. Thank you, Lloyd, for that question. I don't think anybody has gone that far in their thinking, except maybe you and me, Lloyd. I would suggest that you should look at it prior to reporting the student in SEVIS, because you are certifying to the government that this is an F1 student. Most schools only look at it the first time they're reporting on a student because they're new to the United States and they want to make sure that they have been properly admitted to the United States. I have seen some schools that have caught on to the fact that things can go wrong after the first reporting as well, and so that they ask for evidence that the student has been admitted to the United States at least prior to the second reporting. But is there any articulation on this from the government about what to do? The answer is no. But if you have a large number of schools, students, you could be doing this all the time. So I would say that at least in the reporting cycles, you might want to verify it, or at least you have to see it the first time. If a school just completed a conversion, do you still have to go through the recertification? And if so, should you wait until the conversion has been approved? The conversion has absolutely nothing to do with recertification. It's just a way of them getting more evidence about the licensing and accrediting of schools. It has nothing to do with recertification. So you can do them on a parallel course. I would suggest, and that conversion is nothing that has to be approved. So you're simply reporting data. So I would say do your conversion, make sure that's done, because then that becomes part of your new I-17 for recertification. What should a school expect when an ICE visits? Anything. As I said in May when I did this, if it's your SEVP field rep and your SEVP field rep is making their first connection with your school, I don't expect it to be anything dramatic. I expect it to be, hi, this is who I am, and let's get acquainted. And I expect it to be very warm and fuzzy. Other than that, you know, that's just the first go-round. After that, you can expect it could be anything to do with compliance. And compliance is a big subject, like I said. I teach a workshop on it for a full day. So you have to be able to know what the compliance issues are. anything, or it could be records on a specific student, anything. So it can be anything about compliance. But I don't expect that to be the first visit. What needs to be on file for a visit from a SEVIS team? As I said earlier, all records. All records that show that everything you've done in SEVIS has been in compliance with federal requirements. 2 years ago, I attended a session conducted by a rep from SEVIS where they discussed an electronic version of the I-20. Basically, the travel signatures we have to do now could be done electronically. Can you tell me if this will eventually happen? Well, that was part of the proposed SEVIS 2. And so, no, there is no plan for SEVIS 2 any longer. The question is whether or not they would ever change SEVIS 1 to that extent, and I sort of doubt it, frankly. If they do, it would not be for quite a long time. I don't foresee it at the moment. Based on your description of the PDSO, if we wish to make a change of appointment, should we do that before we are visited, or would that be unwise? Well, it depends on who your PDSO is. If your PDSO is not someone who's going to be able to have a really serious discussion with any ICE visitor, I would want that to be changed. And if there is a DSO at the institution who is more knowledgeable, it's a very simple fix on the I-17 to change the role of the DSO to PDSO. So my answer is no, I do not think it is unwise. I think it would be very wise. We issued an I-20. Oops, it's 4 o'clock, so this will be my last one. We issued an I-20 and then did not accept the student. How do we code that student now in our lists? Okay, so obviously you know you're not able to issue an I-20 unless you have evidence that the student was first admitted. So you need to very quickly cancel this Form I-20. Hopefully the person is not in the United States. If the student is in the United States, then I would suggest you contact me directly about how to handle this, and I'll go over it with you. But if the student is not in the United States, Elizabeth, you want to cancel it for the reason offer withdrawn, and do that very, very quickly. Okay? So I don't know why I could no longer hear Karen, but I did the very best I could, and it sounds like you're able to hear Karen as well, just not I. And I hope you will, let me give you my email in case you need me for any reason. This presentation Karen is going to be putting on her website along with these slides. And in the slides, again, is information about our upcoming training programs. And our website is ietstraining.com. And my email address is J, as in June, SD, as in Sadowski Devarez, at ietstraining.com. So if you need to reach me, feel free, and I look forward, hopefully, to doing another webinar for SSAT in the future. Thank you so much.
June, thank you so much. I want to thank our audience for tuning in, and a special thank you to June for this insightful webinar. Just a reminder, I will be posting a recording of this presentation on the webinar page in the professional development section of admission.org. Each of you will receive a link to this page. Most likely tomorrow is when it will be posted. I want to apologize for the technical difficulties that we encountered, but I'm hoping that we were able to salvage enough of this for you. There are a number of questions that were not reached by June today. We had quite a few. So I just want to let you know that I'm going to be sending a report of all the attendees, and that will include all of your questions to June, but also feel free to reach out to her directly if you have a question that you need answered. Thanks again, and have a wonderful day. Bye-bye.